to all of you. Honorable Chief Justice Vishwanath Somadar, Sikkim High Court, Sister Justice Meenakshi Madan Roy and Mr. Madan Roy, Honorable Justice Bhaskar Raj Pradhan, Registrar General Sikkim High Court, Registrar sitting here of the Sikkim High Court, Director Judicial Academy, Member Secretary Legal Services Authority, Secretary Law Department, Dr. Domati Bhutia, President Sikkim High Court Bar Association, Vice President Secretary of the Sikkim High Court Bar Association, senior advocates present here, advocates, friends, dear students, doctor of the Sikkim High Court, ladies and gentlemen. It's my pleasure to be present here before this acclaimed August gathering to share my thoughts on the topic, and I express my gratitude to the members of Sikkim High Court Bar Association for inviting me today on this occasion. Friends, today's topic, writ jurisdiction under Article 226 of the Constitution. If we see from the ancient past what is writ and now what it is, then as I come to know by this time, the writ is a formal order issued by anybody, executive or judicial, authorized to do so. But now by this time, it is by the judicial body or the courts. Therefore, the writ can be understood as a formal written order issued by the court having authority to issue such an order. Orders, warrant, directions, summons. So, this is known as writ. When you are seeing the writ, how it has come, from where, we know our law came from common law. The writ jurisdiction is also started from England. First time the history traces that in 1215 the habeas corpus was originated. Introducing clause 39 in the Magna Carta, it is signed by the King John at that time. And that provision was, at that time it was introduced, no man shall be arrested or imprisoned except by the law, judgment of his peers, and the law of the land. When it was started, but the applications of that habeas corpus came to be started in 1600 at that time. It was waited for a long time, though it was come from 1215, 1600 year, up to 1600 when it was started. Then the writ of mandamus have introduced there, and this, when we see writ of mandamus, then history traces of it that it traced back to the judicial system of medieval England, where the writ would be, it's very important, writ would be purchased from the office of the king. The writs for common grievances slowly came to be known as writs. Of course, it was from here and that the modern day the writs elevated and came to known as writ of mandamus when any right accrues to a person as claim not given. So now it is to writ of mandamus. The writ of prohibition was also there. It correlated with the writ of quo warranto, the writ of prohibition at that time in England. The Crown started the practice of issuing the prerogative orders. Thus, for prerogative orders, the Crown's Justice Supreme over the other courts issued that writ. And the writ of prohibition held first time for the purpose of writ of quo warranto. So that is combinedly issued from prohibition to writ of quo warranto. And you know that it is for usurping the office without authority, that is writ of quo warranto, at that time it was used by the Crown. So this is a history test from English law. Now in other countries also, mainly 2 or 3 types of writs were prevalent. As we can say in Australia, it was habeas corpus, prohibition and quo warranto. In United States, it was also the habeas corpus, prohibition and quo warranto. In France also, it was merely of habeas corpus, nothing else. Now from that, the history traces how in India this writ jurisdiction has been introduced. In India, the writ were first time introduced in 1774 by a royal charter of Britain. The charter created a Supreme Court at Calcutta and conferred on it the right to issue all writs as were issued in England. Later, Supreme Courts of Madras and Bombay were added and conferred similar provisions of issuance of the writ. 3 high courts. First is Calcutta, another Madras, then is Bombay. Then in 1861, Indian High Courts Act came into force. When it came into force, then all 3 Supreme Courts were converted into High Courts. So these 3 Supreme Courts are converted and in the same places, but the power to issue writs as which was confined only to those 3 High Courts, and that too were in their jurisdiction only for writs of prohibition and certiorari. These 2 were. Then pre-constitutional era came. Before the enactment of the Constitution of India, what was the position? These 3 high courts were developed and later on it was given to other high courts, but with a limited jurisdiction. So the pre-constitution era says, before the enactment of the Constitution of India, all high courts had power to issue writ of habeas corpus throughout territories falling under their original and appellate jurisdiction. Only the High Court of Calcutta, Madras and Bombay had the power to issue other writs. The writ of habeas corpus were given to other high courts, but not other 2 writs. Madras, the presidency high courts, power to issue writs were limited to the territorial limits of ordinary civil jurisdiction connected to matters which fell within that jurisdiction. So this was the scenario before the High Court prior to commencement of our Constitution. Now then, in Constitution, Initially, it was Article 202. Initially, when the debate was started for Constituent Assembly. Article 202 was limited to some extent, which is now elaborated in 226, that I will explain. So Article 202 says, notwithstanding anything contained in Article 25, 25 was Article 32 at present, every High Court shall have power throughout the territories in relation to which it exercises a jurisdiction to issue directions or orders in the nature of the writs of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for enforcement of the rights conferred by Part 3 of this Constitution and for any other purpose. So this was the basic article in 202. The debate started. And in the debate, that some debate is correlated to this because the discretionary and extraordinary jurisdiction conferred. So when there is no efficacious alternative remedy, writ. How types of writ? Why? How it has been introduced? In other countries we have seen, in England 4 types, but in other countries it was of 3 types probably writs. So how these 5 types of writs have introduced in our constitution? So this was a part of at that time debate, and some part what should be the writ and order? Can it be in general on being demand or on being asking? So some issue was there. Some of the persons have proposed that the High Court could issue any writ that it considered necessary or appropriate. One proposal. Another proposal, that's the word order in the nature of the writ may be removed. It may be removed. The word writ should not be used. Then they said it should be in the nature, writs in the nature. Should not be in the nature of writ, writs in the nature. Just niceties. Then why 5 types of writs? It was proposed by Dr. Bakshi Tekchand, who was the Chief Justice of the Lahore High Court at the relevant point of time. He said no. Why these 5 types of writs should be essential and it is necessary to be introduced in the Constitution of India. So they proposed in that, and in his debate, some relevant part which I am quoting here, I quote, that these are the writ which I may remind the House have been among the greatest safeguards that the British judicial system has provided for upholding the rights and liberties of the people. It is very necessary that they should be incorporated in our Constitution. At present, the High Court which are not Presidency High Courts, which the High Courts of Allahabad, East Punjab, Patna, Nagpur, Orissa, Assam have not got any of those powers. As I reminded you earlier, that these powers were basically of 3 High Courts for other writs, and for other High Courts it were for habeas corpus. So now this issue has also came. Okay, whether in parlance all the High Court must be given equated power as has been given in other countries, or what should be the way. So this introduced at that time, and then after discussion it was decided no, it should be given at par power to all the High Courts. Then some part which is relevant is, that is those some related with the habeas corpus and other writs, but it is relevant. That in the new constitution, it is intended to give the power to issue these writs to every High Court, which I was saying, every High Court, and will be exercised throughout the territories within its jurisdiction. And in order to put matters beyond doubt, it is necessary that these writs be specifically mentioned. So these 5 writs were mentioned. Sir, we all know that the writ of habeas corpus is the most important of these writs. With regard to this writ, until section 491 was added to the Code of Criminal Procedure, this is old criminal procedure, there was no power to issue this writ in the high courts of Allahabad, Patna, Lahore and Nagpur. Section 491 gave this power to these high courts only partially. Recently, before the East Punjab High Court, the question arose whether the powers and the procedures of the High Court under Section 491 were coextensive with the powers and the procedures of the High Court of England in this matter. As you know, sir, if a writ is refused by one judge, the party can move to a second judge, and in a succession the third judge, fourth judge, and so on until it is exhausted by all the judges. So now in this context it was put up, no, this power of the writ must be given so unambiguously to all the High Court to issue the writ for statutory purposes. And in context thereto, after moderations, Article 226 was introduced. And in the shape of Article 226, though it is somehow later amended, later passed, but the basic article was that article which was introduced was, notwithstanding anything contained in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction. I will emphasize some word because it is having some relevance to my further delivery. To issue to any person or authority, including in appropriate cases any government, within those territories, directions, orders, writs, including writ in the nature of habeas corpus, mandamus, prohibitions, quo warranto, certiorari, and any of them for the enforcement of any of the rights conferred by Part 3 or for any other purposes. Subsection 2 clarifies how and to which territory and to against whom it can be issued. So, Article Clause 3, 226.3 specifies if the interim orders has to be issued. It was not a part of the basic debate. Interim has to be issued, then for what purpose, to what extent interim orders, and later on what would be done. Accordingly, this article 226 was added. You see, everywhere it is Article 32 has been, notwithstanding anything contained in Article 32. So at this stage, Article 32 is very relevant, and I will draw a distinction why it is and for what purpose. If we go off Article 32 to that extent, then we will find that the wording is quite distinct and understandable from that. You see, Article 32 says the right to move the Supreme Court, by appropriate proceedings for enforcement of the rights conferred by this part is guaranteed. Here, first part, it is a right to move to Supreme Court with respect to the relief as specified in Part 3, which is guaranteed. Article 226, wide enough, shall have power. Every High Court shall have power. It is something different. Here the right to move was given. Here the powers were given to the High Court. Shall have power. Then clause 2 says Supreme Court shall have power to issue the directions order of so and so writ appropriate for the enforcement of the right conferred by this part. So this is two part, and subsection 3, and so that is not that much relevant. So here there is a distinction, three types of distinction which can be drawn from Article 226 and 32. Right to move was given of enforcement of the fundamental rights which is guaranteed, and for that purpose Supreme Court can issue the writ of 5 types as specified. The similar words were there: writ of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. That is for, if we see 226, then it comes to enforcement of the fundamental right and for any other purposes. One aspect, another. In 226 we will find writ to any person. This any person has been very nicely elaborated by Calcutta High Court. Who would fall within that? And when I was studying of this, not today, earlier also, I thought it that we see Article 12 of the Constitution where the state is specified, that again is a part 3 of the Constitution of India. If we see that part 3 of the Constitution of India, wherein Article 32 has been specified, 32 and 12, in stricto sensu we see then the writ can be issued in the consonance of Article 12. And when we see Article 226, then the word against a person, authority, or so and so, so and so, so and so. So this is one distinction which can be drawn. Though if we see the interpretation of that, I found it in one old judgment in which this was distinguished by the Supreme Court and said, no, against a person it can be issued. But usually you will find that even under Article 226, the High Courts are not issuing the writs. Now, for this purpose, if we see one judgment of the Calcutta High Court, that is very relevant, and I will point out on this. That was a Hong Kong Shanghai Banking Corporation versus Union of India. In this judgment, the Calcutta High Court, the 2-3 issues came, and a writ is filed by the foreigner, what may be a position, but simultaneously here they have specified in reference to Article 12 authority and person. So at present I am dealing with that issue. So the High Court said that the basic requirement for invoking the jurisdiction of the writ court is that legal right of the complainant should be breached by any person or authority who fits the description of a state under Article 12 of the Constitution of India. Then it says, in exceptional cases, a person or authority who is not a state within the meaning of Article 12 of the Constitution of India can also be subjected to jurisdiction of the writ court, in which they have clarified a person who is not the citizen of India, he cannot claim any writ under Article 226 because the Constitution of India protects the right of the citizen of India. So this is one part. Recently in 2011 also, the same view was reiterated by Calcutta High Court again, and that is in the case of Irvis Engineering Company, in which also they have used the word that the word person includes company. Is pertinent to note while Article 15, 16, 19 confer fundamental right of the citizen, Article 14 confers fundamental right to any person, the distinction between citizen and a person was engrafted in our Constitution by its framers and with a specific intent to grant certain fundamental rights to its citizen and to grant certain rights or legal rights to a person. So there is no ambiguity in the language. They said citizens is claiming, and that too against a person. Can it be? That was the issue. It was answered and said yes, it can be issued and the High Court do have a power under Article 226 of the Constitution.